Hi, good afternoon, everyone. My name is Erin Webb from Community Health Advocates at CSS, and today I'm going to be talking about how to handle medical billing cases. And this training is specifically designed to provide case handlers with a guide for handling medical billing cases, which are a very big part of our practice at CHA. Today we will go over some common billing issues, the general steps to solve a medical debt case, balance bills, surprise bills, hospital financial assistance, emergency services, and debt negotiation. But first, what are the common billing issues that might arise when you encounter a medical billing case? You may hear your client say something similar to what you see in these talk bubbles. What you'll find is that many medical billing issues stem from one of the following major issues. Number one, lack of knowledge. Clients just don't know things sometimes. Clients sometimes don't know the difference between an explanation of benefits and an actual bill. Clients don't know whether hospitals and provider bills come separately. Clients don't know the difference between their cost sharing and a balance bill. Clients may not know when or where to ask these cost-related questions that come up. And clients don't know when denied claims will be resubmitted, processed, and accepted. Number two, the volume of communication in billing cases can be overwhelming. Clients receive a large number of documents from payers, from multiple providers, and from third-party benefit managers, sometimes for a single medical event. Number three, understandability or difficulty understanding what their documents mean. Bills and explanation of benefits describe the same charge differently sometimes, and hospitalization charges are divided on a bill. Bills are confusing. Number four, timing issues. Clients don't know when a claim is processed and settled. That is, it may take months before the client receives their final bill with the adjusted balance. And number five is trust, or really a lack of trust. Lack of trust can be a major barrier to overcome that leads to bills getting out of control. And billing issues can lead to distrust of the provider or distrust of their insurance company. Before we get into the steps taken to help your client, let's review the billing process and how bills come about. So first, the client sees the doctor. Then the doctor's office submits a claim to the insurance company. The insurance company reviews and pays their share, if any. The client receives an explanation of benefits from the insurance. Then the client receives the bill from the doctor's office. If the client doesn't pay the bill, the account may be referred to a collections agency. Clients may be calling about cost-sharing bills, which include co-payments, co-insurance, and deductibles, balance bills, which are bills from out-of-network providers, bills for services that their insurance denied paying for example, a surgery or an inpatient hospital admission, and bills that their insurance denied paying for because the client needed to get prior approval by the plan and didn't. Now we'll review the general steps to take in order to help your client solve their medical debt issues. There are 3 steps that you should take in every medical bill case, no matter the type of bill. Step number 1, determine if your client was insured or uninsured on the date of service. Step number 2, determine the type of bill you're dealing with. For example, is this a hospital bill or a doctor bill? And number 3, determine the best solution to fit your client's billing issue. We're going to run through a few billing scenarios to illustrate how these steps would be applied in practice. So, step number 1. is the client insured or uninsured? Here, the slide tells you that the client was insured. Step number 2, what type of bill are we dealing with? Here, the slide tells us we have a hospital bill. So now you move on to step number 3, which is the analysis that you see in the body of the slide. The best solutions will depend on whether the hospital bill is the client's cost sharing or a balance bill. If it's cost sharing, then you should verify if the amount is accurate by checking the explanation of benefits or the plan's contract. If the amount is accurate, then the client owes it, and you should ask if the client can afford to pay it. If not, help the client negotiate the debt or establish a payment plan. If the cost-sharing amount is determined to be incorrect, then you should try and correct it. To do that, you should call the plan. On the other hand, if this is a hospital balance bill, you'd want to consider if any protections from balance billing apply. For instance, Medicaid or qualified Medicare beneficiaries have protections against balance billing. If not, ask if hospital financial assistance is available and if your client might be eligible. If hospital financial assistance is not an option, then you might have to move on to debt negotiation with the hospital billing office or any other resources that you may be aware of to help your client, like the New York Times Medias Cases grant. Second scenario, we have the same analysis. Step 1 is the client insured or uninsured. Here we know the client is insured. And step 2, what type of bill are we dealing with? Here it's a provider bill. Step 3 is the analysis. Is this a cost-sharing bill? And if so, verify if the amount the client is being billed is correct. Or is this a balance bill? Could a balance bill protection apply? Here, because it's a physician bill for an out-of-network physician, you'd want to check whether or not it's a surprise bill. And if so, take the necessary steps to dispute it. And when all else fails, try to negotiate down the debt with the doctor and explore other resources you may know about to relieve the client's financial burden. Now, if in step number 1, you determine that your client was uninsured on the date of service, you should take the additional step of trying to get your client coverage retroactively to cover the bill. So we're going to review some retroactive coverage rules that you should memorize and apply to your cases. So remember, Medicaid can go back 3 months from the date of the application. So if your client is eligible for Medicaid, you should help your client apply and request that the start date be backdated up to 3 months. If the bill that they have falls within that 3-month retroactive coverage period, Medicaid can pay the bill. If your client had employer coverage and lost that coverage, you should try and get the client reinstated. You can call the HR department or the employee benefit administrator to see if they can be reinstated. Sometimes we have clients that had coverage through their job and then lost coverage and became uninsured because they left their job. And those clients are sometimes offered COBRA, which means that they can keep their old job health insurance if they pay for it plus a little extra. A lot of clients decide not to take COBRA because they're paying the full amount plus extra for their insurance, and it can be very expensive. However, you should know that clients can select COBRA within 60 days of receiving the COBRA election notice from their old employer. This might be important if your client is sick or injured 60 days after they left their job and didn't take COBRA, because they can elect COBRA to help cover the bill and have insurance pay for it. This would really only make sense if the bill that they have is a lot more expensive than the cost of reinstating COBRA. But if after you've exhausted these possible ways to get retroactive coverage, your client is still uninsured, then you should proceed to the next steps. So here's step one, insured versus uninsured. Our client in this case is uninsured. And step two, what type of bill do we have? Here we have a hospital bill. Remember that extra step, can they get retroactive coverage? And if not, proceed to step three, which is to determine the best solution. Because in this case, we're dealing with a hospital bill, the client might qualify for hospital financial assistance. If the client is liable for the bill and cannot get hospital financial assistance to help cover the bill, then proceed to debt negotiation with the hospital billing department or consider other resources available. Here, our client is uninsured and has a provider bill. They cannot get retroactive coverage, let's say. So in step number three, we would ask whether the doctor treated the client in a hospital or was this an outpatient appointment that they scheduled. If the client saw this doctor at a hospital, you should check whether the doctor is covered by the hospital's hospital financial assistance policy, and if so, consider applying. Or you might think that this is a surprise bill, and your uninsured client may be able to dispute this bill through the process known as independent dispute resolution, which we'll talk about later. However, if the bill is from an outpatient visit that the client scheduled on their own, then they're responsible for the bill, and you should try and negotiate the debt with the provider. So I mentioned in step number three that if your client has a bill, you should consider whether any balance billing protections apply. So we're going to review some of the balance billing protections so that you're familiar with the concept before you start taking cases. This is what the three steps look like in the context of balance billing protections. You'd see that you'd be asking this question in the analysis part of step three. So first you need to understand why the client is being balance billed. It's usually because the provider is out of network. So you would do your surprise billing analysis in that case. But it could also be that the provider just doesn't have accurate insurance information on file. So in order to rectify that, you would simply call the provider with the client and give them the updated insurance information so that they can submit the claim to the correct insurance. If this happens, you should let the client know that it can take 30 to 45 days for this claim to be reprocessed through the correct insurance, and that if they receive notices during that time, they may not reflect the accurate balance. But if the insurance information is correct, and after you've done your analysis, you've determined that it's not a surprise bill, then you should check to see if any other balance billing protections apply. So here we have a few balance billing protections that you should memorize. Medicaid enrollees can't be balance billed, and qualified Medicare beneficiaries can't be balance billed. And there are links provided here if you want to review the rules that explain that. For commercial and fully insured enrollees, they have to read their plan's contract to understand the policy about balance billing, but in general, hospitals and providers that are part of an HMO network can't balance bill. And if you have a client where they have a service denied for a specific reason like lack of medical necessity or lack of prior authorization, then they may have appeal rights and you may be helping them file an appeal. So let's take a closer look at what a potential surprise bills case looks like. Here are the three steps. Notice that in surprise billing cases, the answer in step number 2 will always be provider or physician bill, not an ambulance bill and not a hospital bill. And this is because the surprise bill law only applies to out-of-network doctor bills. Let's review the surprise bill law. As of March 31st, 2015, New York State expanded protections for out-of-network emergency services and created protections against out-of-network surprise bills. Before this law, only HMO enrollees were protected from out-of-network emergency services bills, but these protections now apply to all fully insured plans. This law protects consumers from out-of-network bills in limited specific circumstances, which we will discuss. And it can be challenging to determine which bills are actually protected. Fully insured enrollees are held harmless from emergency services and surprise bills, and they are only responsible to pay their cost sharing. While self-insured and uninsured enrollees are not held harmless, but they can dispute the out-of-network physician bill and surprise bill through the independent dispute resolution process. The protections from balance billing and surprise bills cases are different depending on whether your client is covered by a fully insured or a self-insured plan. So as a review, a fully insured plan is one where the employer pays monthly premiums to an insurance company, and the insurance company assumes the risk of paying healthcare costs. If the employees get very sick, the insurance company loses money. Fully insured plans are subject to New York law and under the jurisdiction of the New York Department of Financial Services. Self-insured plans, on the other hand, are where the employer pays the employee's healthcare costs out of its own funds, but often hires an insurance company to administer the plan. If employees get very sick, the employer loses money. Self-insured plans are subject to federal law, and complaints are under the jurisdiction of the U.S. Department of Labor. If your client is enrolled in a New York State of Health plan or a Medicaid plan, then you'll know that it's a fully insured plan. Otherwise, you likely have to call the plan and ask, or check in the benefits booklet. Whether or not your client's bill will qualify as a surprise bill under the law will also depend on whether their plan is fully or self-insured. So let's review both. First up is the fully insured surprise bills. There are two scenarios where a fully insured client will get a surprise bill. Number one is at an in-network hospital or ambulatory surgical center. And number two, if an in-network physician refers them out of network. Let's go over both in detail. So in the first scenario, you have a client who goes to an in-network hospital or ambulatory care center, and an out-of-network doctor treats her, and one of the following is true. There was no in-network doctor available. The client had no knowledge that the doctor was out of network, or an out-of-network doctor was needed because of unforeseen medical circumstances. Let's go over a real case example to illustrate this scenario. You have a client that calls CHA because they received a bill from an anesthesiologist for $25,000. Some questions to ask the client are, how did the client come to see the anesthesiologist? The client tells you that they had a scheduled surgery and the anesthesiologist was a part of that surgical team. Was the hospital in network? The client tells you yes. And ask if the client is getting any other bills from the other providers involved. The client, in this example, says no. The primary surgeon requested prior authorization, which was granted because the surgery was considered medically necessary and the surgeon was in network. So based on this information, what can we tell the client? Well, the bill might be a surprise bill if you can establish that some of these additional facts are true. In one scenario, the in-network anesthesiologist on call called out sick that day of the client surgery, and there was only one anesthesiologist available that day who happened to be out of network. Scenario 2, in the operating room, the anesthesiologist administered anesthesia to the client but never informed the client that he was out of network. Or scenario 3, the client surgery went wrong and another anesthesiologist was called in to help save the client's life, and that would constitute an unforeseen medical circumstance. If either of these three scenarios are the case, then it's highly likely that your client's anesthesiology bill is a surprise bill. So surprise bill scenario number 2 is the physician referral. In this case, the client is treated by an in-network doctor, and the in-network doctor sends blood or specimens to an out-of-network lab or prescribes an out-of-network device like a heart monitor without the client's knowledge or written consent to go out of network. Or the client is billed for any other services performed by an out-of-network doctor if the client's plan requires a referral. So for example, your client has an HMO that requires referrals to see a specialist. They go to their in-network primary care physician and they're referred to an out-of-network specialist. The out-of-network specialist bill would be a surprise bill. Or an out-of-network doctor treats the client at an in-network doctor's office during the course of the same visit. I want to make a quick note about out-of-state services and surprise bills because this comes up occasionally. So sometimes we have clients who live in New York State, but for some reason they had to receive care by an out-of-network doctor while they were traveling out of state. And they know about the New York surprise bill law, and they want to know if it's going to protect them. The answer is it depends. It depends on if the facts of the client's case meet this two-part test. So the test is that, number one, part of the service was performed in New York State, and the out-of-state, out-of-network provider involved has a sufficient nexus with New York State. So what might this look like in practice? Let's say your client goes to their in-network doctor who is located in New York, and the doctor draws blood. That doctor sends the blood samples to an out-of-network lab that's located in Massachusetts without the client's knowledge or written consent to do so. Let's say that this Massachusetts lab is the same lab the doctor uses for every patient. In this example, the out-of-network, out-of-state lab bill would be a surprise bill because it meets the two-part test. Part of the service was performed in New York State. The actual drawing of specimen of the blood happened in the New York doctor's office. And there is a sufficient nexus to New York because the New York doctor regularly does business with an out-of-state lab. As you can probably imagine, there are many cases where they don't meet this two-part test, and clients are often not protected when they receive out-of-network services out of state under the surprise bill law. But other protections against balanced billing may apply. So let's do an example to illustrate the physician referral surprise bill. Your client calls CHA because he received a bill for $3,000 from Quest Labs for processing blood work. Questions to ask. Did Quest Labs submit the claim to insurance? You always want to maximize insurance payments, so it's good to get in the habit of asking this question in every case. But let's say yes, the client called Quest and they said that it was denied by insurance because Quest was out of network. There was no issue with not submitting the claim at all. Next, you would ask, was the provider who drew the labs in network? The client tells you yes. It was their primary care physician. might ask, was the client aware that the provider was sending the labs to an out-of-network facility? And the client tells you no, the client wasn't informed and never signed any kind of acknowledgement or written consent. So based on these facts, what can we tell the client? Well, this could be a surprise bill, and the client should follow the surprise billing steps. Let's do another example. The client calls because they got a bill from a heart monitor equipment provider for $1,000. Questions to ask the client. Did the heart monitor provider submit the claim to insurance? Always checking for that. In this case, the client says yes, and it was denied because the heart monitor equipment provider was out of network. You should ask, was the provider who ordered the heart monitor in network? The client tells you yes, their primary care physician prescribed the device and referred them to a local hospital to pick it up. However, the provider that analyzes the data obtained by the monitor is based in Texas and is out of network. Was the client informed that the provider and device were out of network? In this case, the client tells you no, and they did not give written consent to be sent out of network. Based on these facts, this bill may be a surprise bill, as long as there is a sufficient nexus between the provider in Texas and New York State. So this example has a little added twist with the out-of-state issue. Now let's review surprise bill scenarios for self-insured and uninsured clients. Remember, self-insured plans don't have to follow New York State laws. They only have to follow federal law. The surprise bill law is a New York State law. So clients are not held harmless. Self-insured clients are not held harmless, but this law does give these clients some options. Self-insured clients that get bills from out-of-network doctors that didn't properly disclose that they were out of network may dispute the charges as unreasonable through a process known as the independent dispute resolution process. When the surprise bill law passed, it amended sections of the New York Public Health Law to add disclosure requirements that hospitals and physicians in private practice have to abide by in order to inform patients of their network status. The Department of Health has a frequently asked question resource that's really great and explains all of the disclosure requirements mandated under the law, but you can read it on your own. But here are some, but not all, of the disclosure requirements under the public health law, just to give you an idea. So you see that hospitals are now required to post the plans they accept on their website. They have to post a disclaimer that some doctors that work at the hospital might not take the same insurance as the hospital itself. And if there is an admission for a non-emergency service, they're supposed to advise the patient to check with the physician who's arranging this hospitalization for how to determine what insurance the other treating physicians accept. Physicians in private practice have requirements to disclose their network status too. For non-emergency services, they're supposed to disclose in writing or online what insurance they accept. They are also required to disclose this information verbally at the appointment. And if it turns out that they are out of network, they have to inform the client that the amount that the provider will bill is available upon request. And if the patient requests this information, they must disclose that amount in writing. They are also required to provide their name, address, and contact information of the other providers that may provide services. Now that you're able to correctly identify surprise bills, let's review the protections afforded by the law. If your client is enrolled in a fully insured plan and you determine that they've received a surprise bill, then they should be held harmless, and in order to do that, they should assign benefits. To assign benefits, the client must complete the Assignment of Benefits form, which is available on the Department of Financial Services website, and submit the completed form and a copy of the bill to both the out-of-network provider and the health plan. If your client is enrolled in a self-insured plan, first determine whether the provider complied with the disclosure requirements in the public health law. If the provider did not comply, consider submitting a dispute to the independent dispute resolution process. Here is an image of the Assignment of Benefits form, and as you can see, it's pretty straightforward. Just includes the the patient's information, the provider's information, and the insurance company information. The patient should fill out 2 copies of this form and send one to the provider and one to the insurance company, along with a copy of the bill. This is an image of the patient application for the independent dispute resolution process. One thing to keep in mind is that there is a fee associated with this process, but it only applies if the client loses the IDR. The fee goes up a little bit every year. Last time I checked, it was around $390, so that can weigh into your consideration when you're advising your client that maybe this isn't the right way to dispute the bill if the bill is worth less than the value of the fee. I want to direct your attention to this. It's very small, so it may be hard to read, but what this checklist is aiming to get at is the disclosure requirements. So it will say, my physician did not tell me, and then some of the things that they're obligated to disclose, or my hospital did not post on its website some of the things they're required to disclose. So here's where your client would establish the disclosure was not met and be eligible to dispute the bill through this process. So there are certain circumstances that you may be surprised to learn are not surprise bills. If a patient is admitted to an out-of-network hospital and is treated by an out-of-network provider, then it's not a surprise bill. Remember that when I was going over the surprise bills for fully insured enrollees, the hospital has to be in-network. A participating provider that is not a physician, like a speech therapist or any unlicensed provider who refers a client to an out-of-network doctor, is not going to result in a surprise bill, because in the statute it's very specific and says that it's only when a physician, a licensed physician, refers you out of network that you will get a surprise bill situation. A participating physician that provides your client with a list of local labs and recommends that the client make an appointment to get blood drawn, and your client picks one from that list that happens to be out of network, that's not going to be a physician referral, and it's not going to be a surprise bill when they get billed. If your client, is given misinformation by a health plan representative or looks on the plan's provider directory for a doctor and picks one on that list that turns out to be out of network, unfortunately, that will not qualify as a surprise bill. If this happens to your client, and it's highly likely that this will happen to all of you at least once, you should file a complaint with the Department of Financial Services against the plan, because we are trying to track the prevalence of this problem, and unfortunately the only recourse would be trying to negotiate the debt. Next, we're going to review a valuable recourse for many of our clients that receive hospital bills, and that's hospital financial assistance. Here are the 3 steps. Notice that in step number 2, the answer is always it's always hospital, not provider bills, except for in a few exceptions. So before applying for hospital financial assistance, first, as always, determine whether insurance can pay more or pay at all if they haven't, or if the consumer can be held harmless. This might involve asking the hospital to resubmit the claim under a different code. Sometimes inpatient hospitalizations are denied by the insurance company because they say the level of care is too high. The hospital may be able to resubmit the claim under an outpatient or observation status, which is a lower level of care, to trigger payment by the insurance company. If you have a client that is dealing with a medical necessity denial or an experimental service denial, then you may need to help the client appeal with the insurance company to get the claim paid. If your client is uninsured or the service is not covered, then you'd always check if the client can get retroactive coverage in order to cover the date of service. So remember, Medicaid can go back 3 months from the date of the application. Employer coverage, the only way to be reinstated will be dealing with the employer, and the COBRA rule of 60 days after being offered COBRA to elect COBRA. So in general, hospital financial assistance is only offered to cover hospital bills, not doctor bills. But the exception is that doctors that are employees of the hospital are bound to the hospital's financial assistance policy. So in that case, your client may be able to apply for hospital financial assistance to cover the doctor bill. Sometimes doctors that are not employees of the hospital but may have privileges at the hospital will nevertheless offer discounts on their bills if your client gets approved for hospital financial assistance towards their hospital bill. When you have a hospital billing case and you think that hospital financial assistance might apply, you should screen your client for eligibility. So you'd want to verify New York State residency. Remember that there is no immigration or citizenship status requirement under the hospital financial assistance law, so you don't need to prove that they're a U.S. citizen or even that they're documented at all. Patients are eligible if their household income is 300% of poverty or below. However, an individual hospital's policy may award financial assistance to households above 300%, and a lot of them do. So it's really important to check the hospital, the specific hospital that your client is dealing with for their policy, which is typically available online for their income limits. Once you've determined that your client is likely eligible, then you should help them apply. Hospitals are required to post their summary of their policy, their actual application, and their entire policy on their website. So print the application for the client and help them fill it out if they need help. Gather the required supporting documents from the client and attach it to the application, and then submit the application to the hospital. If your client doesn't quite meet the income eligibility requirements, but can show an inability to pay the bill based on their expenses, then you may want to consider applying for financial assistance anyway, because the hospital can't send their account to collections while the application is pending, and if they inevitably get denied, then they can appeal that denial, and they can offer proof of their inability to pay because of their financial hardship. That often results in awards on appeal. Every hospital has its own financial assistance policy, and they can each ask for different things. But the hospital financial assistance law does set some rules for what documents the hospital can and cannot ask for. They can ask clients to submit pay stubs or other proof of income. They can ask for proof of residency. They can conduct an assets test if the household income is under 150% of poverty, and they can conduct soft credit scoring that doesn't affect the client's FICO score. but they cannot require copies of the client's tax returns with the application. They cannot require proof of citizenship. They cannot ask for a social security number. They cannot conduct an assets test if the household income is above 150% of poverty, and they cannot require the client to send in copies of their monthly bills and expenses, although this information is often used, at least in our practice, to help establish financial hardship. Under the law, your client has the right to appeal any decision that she disagrees with, and that includes both denials and awards. And you can help the client appeal. When you're appealing denials and awards, you should make sure that you follow the hospital's appeal timeframe. Hospitals set their own timelines for their appeals process. It's not prescribed in the law, so you have to look up what your hospital allows. However, the law does state that denial letters have to detail the basis for their denial. A few words isn't enough. So you can appeal a denial if you believe that the client was actually eligible and was wrongly denied, or you believe that the hospital's reason for the denial is not sufficiently detailed. You can also appeal awards and ask for a greater discount. The law states that a hospital can give financial assistance to clients that are above the eligibility threshold but can demonstrate an inability to pay. To do this, you should gather supporting documents from the client, like their monthly expenses, proof of other debts that they have, their recent pay stubs, and then put it all together in a compelling hardship letter. If the hospital continues to deny a clearly eligible client or otherwise violates the hospital financial assistance law or their own policy in any way, then you should submit a complaint to the New York State Department of Health. And there's a link provided here to access the complaint form. Next, we're going to review the protections available for emergency services bills. These can be hospital, or really emergency room, or physician bills, but they're always bills for services that are performed in the emergency room or emergency department. Emergency services regarding bills is specifically defined, and it may be different than what your client thinks qualifies as an emergency. So the official definition of an emergency condition for purposes of medical billing means that a medical or behavioral condition, the onset of which is sudden, that manifests itself by symptoms of sufficient severity, including severe pain, that a prudent layperson possessing an average knowledge of medicine and health could reasonably expect the absence of immediate medical attention to result in A, placing the health of the person afflicted with such condition in serious jeopardy, or in the case of a behavioral condition, placing the health of such a person or others in serious jeopardy, or B, serious impairment to such person's bodily functions, C, serious dysfunction of any bodily organ or part of such person, or D, serious disfigurement of such person. To determine the recourse available for consumers who receive emergency services bills, you want to go through the following steps. Step 1, confirm that the bill is truly for an emergency service according to that definition. So these bills can either be from an emergency room or a provider who provided emergency services in the emergency room. Step 2, determine if the bill is for their cost sharing or if they're being balance billed. If it's cost sharing, you might be able to apply for hospital financial assistance. If it's a balance bill, check if a balance billing protection applies and continue to step 3. And step 3 is to determine if the plan is fully or self-insured. If it's fully insured, then your client may be able to assign benefits and be held harmless, but for their cost sharing. If it's they're in a self-insured plan, then you'd want to determine whether the provider complied with the disclosure requirements in the public health law. If they did not comply, then consider submitting a dispute to IDR. Your client may also want to explore hospital financial assistance to cover the costs of the hospital bill. Finally, we're going to review the last resort option for every single billing case, and that is debt negotiation. So here are the 3 steps. Debt negotiation is always available and used as a last resort, so it's always going to be in step 3. First, you should verify whether this debt is valid. Check the bill's date of service, check what services were performed, and confirm that the client really received the service the hospital or the doctor says they received. Before negotiating, remember to exhaust all of your other recourses that we discussed in this training. Remember that debt negotiation truly is a last resort. So when you are negotiating with a provider, you should ask if the provider is a hospital, so is this a hospital bill or facility in a hospital system? And if so, can your client apply for hospital financial assistance before negotiating? You can check the fair market price for the service that your client received on fairhealthconsumer.org. The fair market price is the amount that providers regularly charge for the same service in that area. It's based on zip code. And you can look it up at this website. And this is useful in negotiations because it will help you determine whether your client's provider was overcharging and what a more fair amount would be if your client wants to pay less. You should tell the provider about the cost of the care and explain the client's financial situation and just ask for a discount. Many providers are very familiar with negotiating. You won't be the first one to try it, so sometimes you just have to ask. If your client is living on a fixed income or has a very low income, or if there are other factors that make it difficult to pay, then write a letter of financial hardship to the doctor. If you're negotiating with a debt collector, then you should know that your client has special rights under the law, but your client must be aware that if they ignore this forever, then they can be sued for the debt. Here are some tips to help you negotiate when you're starting out. Over time, you'll develop innate skills and you won't need to refer to anything for help. Negotiating really is an art, not a science. If you've determined that your client will have to pay an amount that she cannot afford, don't be afraid to try. Ask if the provider has a policy on bill reduction, for example, a percent that they will reduce the debt. Sometimes it's good to know that up front so you know that the most discount you can get is, let's say, 25% or whatever the policy is. Always write a compelling hardship letter if the facts allow, and provide supporting documents when you can. It's true, mention that the client is a long-term patient of the practice. And when you're considering your opening offer, ask your client what she can realistically afford to pay. Use this to anchor your negotiations. So you want to start with a very low number. So for example, if the debt is $1,000 and she can only afford to pay $500, then you don't want to offer $500 first, because if the doctor rejects that, you have nowhere to go. So you'd want to start lower, like $200. Consider offering a lesser payment in one lump sum, as opposed to monthly payment plans. So often debt collectors will close an account if the client pays one time for a lesser amount, as opposed to the payment plans over a long period of time, like very low payment plans. We're talking like $5, $10. A lot of debt collectors will not accept something like that, but they might accept a lump sum payment that's a lot less than the full amount. If your client can't afford to pay in one lump sum, most providers and hospitals and creditors will work with the client to set up a payment plan. Make sure that your client can truly afford to pay the amount that she agrees to. You don't want to get into some kind of a default situation. Review any settlement agreements carefully before your client signs them and make sure that your client understands all of the terms. If you have the opportunity, you should try and get a clause in the settlement agreement that says that if the client does default, that the creditor will give her some kind of notice and not take any further action for 30 days or 10 days or some amount of time that allows the client to cure the default. And we've reached the end of the training. I hope that this information is useful to you. And if you have any questions, you can contact me directly. I'll make sure that my contact information gets put up on these slides.